That completes my exam. Thank you.
Thank you.
Okay, Cross. And I just would note in the matter that you have beaten your estimated time by by 10 minutes. So 50 minutes rather than
Thank you.
60 to 90. I just want to give credit where credit's due. So
Great, thank you.
go ahead. Go ahead.
All right, Ms. White, you provided some testimony about financial statements of the company that were provided to you. Do you recall that?
Yes.
And they were two separate exhibits that were shown to you. Other than those exhibits, as a nurse practitioner, did you have access to the company's financial statements other than those documents that you testified about?
No.
So have you seen any financial statements from the company after the ones that were presented to you in connection with the offer for you to buy into the practice?
No.
Now, and when you were hired by the company, you were hired as a nurse practitioner, correct?
Correct.
But you weren't hired as a lab technician, correct?
Correct.
You also weren't hired to be a lab director, is that correct?
Correct.
And then I believe you said that the company eventually approved your request for a 2-week leave of absence. Recall that testimony?
Yeah.
But isn't it true that the company approved your 2-week leave of absence on the same day that you provided them with your request for the 2 weeks of leave?
I wouldn't say they approved it the same day. I told them I was going to be taking a 2-week leave. And after multiple hoops that I had to jump through, it was approved. I would definitely not say on that day they approved it.
Let me show you respondents exhibit number 16. This is a document that's already been admitted to evidence. It appears to be an email from yourself to Justin dated October 15th, 2018. Is that correct?
Yes.
And in this email, is it fair to say that you informed Justin that your doctor had sent over paperwork and that he recommended that due to your rheumatoid arthritis flare, you take 2 weeks off so that the flare would calm down? Is that correct?
Yes.
Now, in your communications with Justin Pulliam or Brad or any other manager of New Medical regarding your request for a leave of absence or accommodations, were they all done via email or were any telephonic?
Via email.
All right, I'm now going to show you what is marked as Respondents Exhibit 18. Specifically, document number 840.
Yes.
This is a letter to you dated October 15, 2018, in which the company approves your 2-week leave of absence. Is that correct?
Yes.
You scroll up a little bit further. There's an email from Jody Stark to yourself transmitting that leave letter, correct?
Yes.
And that's also dated October 15th, 2018, correct?
Yes.
And so In addition to the company granting your 2-week request for time off to deal with the flare-up, isn't it true that the company also accommodated your request not to work Fridays?
When I first started, they accommodated the request. When I requested to keep my 4-day schedule, I wouldn't say accommodating is the word, because accommodating is the last thing that they were. Did they allow it eventually? Yes. All the emails just stopped coming, but I wouldn't say they were accommodating about it.
Did the company ever require you to work a Friday after that October 2nd, 2018 email?
I never had any follow-up after that email, no.
So the answer is no, the company never, or the answer, did the company ever require you to work a Friday?
No.
You also testified about a conversation you had with Jody Stark, where she explained kind of the internal processes the company used in corresponding with you about your leave. Do you recall that?
Yes.
You had these conversations with Jody Stark. Was Jody Stark still employed by New Medical?
She was not.
All right. In terms of, you recall what position Tiffany Seaman was hired into for the company?
Medical assistant.
As medical assistant, was Tiffany Seaman qualified to become a CLIA certified lab director?
Yeah, anybody can be CLIA certified. You don't need specific requirements. You just need to do their tests. So yes, she was certified.
Let me make this clear. The question was she eligible to become a CLIA director?
A director, I wouldn't know what the term director would mean for CLIA, but she was qualified to run the lab.
Okay, but do you know whether or not she was qualified to be a director of a lab?
I do not.
Any of the other individuals that you may have observed for New Medical working the lab, are you aware if any of those individuals met the qualification requirements to become a lab director?
I would like to know what the definition of lab director is, because Julie Driscoll was a lab director, and so was everybody else that ran the lab. So I think New Femme and New Male basically call anybody who can run the labs a lab director. I don't think they did anything different than anyone else who ran the lab. So I would like to know the terminology definition behind director.
Well, let me ask you this. Are you familiar with any regulatory definition or requirements to become a lab director?
You needed to be CLIA certified.
And do you know what those requirements entail?
I do not know the exact ones because I was never asked to do it and I never did do it.
I have nothing further.
Any redirect?
No, thank you.
Okay, then I would say you're excused, but it's your case. So you're not. So, okay, then you have your So my understanding, just to check, and we need to go through this. That my understanding of the complaint rests, is that correct?
We rest with the understanding that we're not precluded from putting in rebuttal evidence.
Right, and dealing with if there's new things presented, I just want to go over them. My understanding is that you wanted the, let's go over the exhibits. My understanding is you wanted those profit and loss statements admitted into evidence.
Yes.
Any objection?
No objection.
Okay, I'll respond. I'll receive complainants 1 and 2.
I believe it's
2 and 3.
complainants 2 and 3.
You're right. You're correct. 2 and 3. My understanding is that we have not had testimony regarding the 627 check. Is that something that's needed, or is that withdrawn?
We'll withdraw that.
Okay. All right. And you haven't had testimony about the separation and release agreement. Is that needed in some manner?
No, we'll withdraw that, and we'll withdraw the Facebook posts
Okay.
unless the respondent is going to refer to any of that.
Okay. Well, you can undo that if there's and my understanding is that then the all of the complainants' exhibits have been ruled on. Is that right?
I believe so.
All right. So then, okay. So, and I just would note in, for when you go off through, is there anything else that needs to be done prior to resting your case? As I said, that I'm wouldn't consider in any kind of in these matters of any ruling at this point, and that you have a right to cross and any witnesses presented by the respondent and rebut things presented by the respondent, but that since I don't allow rebuttal, it's strictly limited to new things that have been presented or brought up by the respondent. Now, just for I'm going to, in the manner to send you both what I have for for the witness okay. And I'm just going to send that like I know in the close of the respondent's case that I will do the same. Is there anything we need to, so that I want you to be able to have exactly what's going to go on the record as far as the list of exhibits. And so if there's any need for correction that we do it. Is there, is the first respondent's exhibit ready to testify?
They are. I wanted to just raise one thing. I didn't see anything attached to the email that just came through from you.
You didn't? Okay, well, I was trying to do this and talk at the same time, which is a dangerous thing to do. If I didn't, then I will try it again.
Thank you. I appreciate that. And number 2, I will get respondents' first witness available, but if we could take just a 5-minute.
Yeah, I was going to give you, Yeah, I think so. Let me try it again when I put the attached to file. Yes, I don't think I did that. That's what happens. I am multitasking is not my best thing here. So okay, that'll be better with. Try that. That is something attached. Okay, so then we'll take 5 when you get ready and switch gears. And just simply to note, and then also to get it so that you can update your witnesses and see what you think is appropriate for lining up for this afternoon. So we'll take 5.
And if I can, from a procedural matter, just because we are going through the hearing much quicker and to the extent we can squeeze as much as we can in today, will you be asking or allowing for closing arguments?
I don't, that dealing with, and I'll just still it on there. No, you can have doing those in writing. I don't, since this is not a process which, for which emotional appeals has any basis whatsoever, which is the main use for closing arguments. I am interested in thoughtful, maybe even briefs that that are related that suggest that you've been at the same hearing I've been at. Because it's really, if it, that's kind of important, because if you're talking about stuff that I never saw, then I'm saying, where was I then? So then, no, I just dealing with, if you want to do argument, do it thoughtful and in writing. Does that answer your question?
That does, thank you.
Okay, I mean, just to check on that matter, it's either party at this point, and certainly there is a particular legal issue that I just would note that I would, we have a legal question as to, I mean, to some degree, though, my understanding is that the prime thing that there's a variety of other issues, but the main issue is in dealing with the determination, correct? Because that, when we have these other things regarding accommodation or not or whatever, eventually that there was an accommodation given, correct, Mr. Olson, so that there really isn't a failure to accommodate to rule on particularly, right? And that she acknowledged that she never had to work on a Friday.
Yeah, the claim is for retaliation and discrimination on the basis of her status and her opposition.
Okay, and in dealing with that, I thought in the matter, and this is, let me just. One of the reasons why I put in the claim is that, just to note that there isn't an opposition claim in this case, so there's no retaliation case. Correct?
I misspoke on that.
Okay,
Yeah,
well,
so
I just
wanted
to show you. I was listening to you. That's the matter.
I appreciate that.
I was paying attention. So my understanding is that the prime issue, and there's things that lead up to regarding what happened before, but we're basically dealing with the prime thing that we have is issues regarding the discharge. Correct. So
I agree.
So and there in the circumstances that it appears as though among the things that is simply to note that I don't at this point, as I understand it, have a clarity, Mr. Olson, as to how you think the earlier events connect to the discharge decision, and so or don't. So anyway, it would seem, do the parties want to submit briefs?
Yeah, we'll submit briefs.
Okay,
Yes.
so normally it's, and is 30 days simultaneous with then a 15-day response period, because I'm not sure whether there is a, that in some cases, I view that the parties have explored and it's quite clear what their arguments are, and not, rebuttal may not be needed, but this one I'm not so sure that I have heard either of your arguments precisely regarding this. So in 15 days for responsive briefing,
That
does that
works
work for
for
both of you?
30 and fine with us.
Yeah, and
It's
I just
fine
would
with the
note as
complainant.
well that if you stipulate to with each other regarding modify the dates depending on vacations or whatever, the situation, work it out if you need a slight tinkering with those dates. Okay.
Sounds good, Judge.
Okay.
Okay. So, does that answer your questions regarding closing stuff?
Yes, it does. Thank you.
All right, then we'll go pause for about 5 minutes as you assess your afternoon. All right, sir, would you raise your right hand, please? Do you solemnly swear the testimony about to give in this matter be the truth, whole truth, and nothing but the truth?
I do.
Okay, then go ahead, whichever of you is questioning him. And could you just please state and spell your name?
Yes, Justin Pulliam. It's Justin, and then P as in Paul, Ulliam as in Mary.
Okay. So go ahead with the direct.
Mr. Pulliam, are you currently employed?
I am.
Where do you work?
For New Mill Corporation.
And what is your position with New Mail Corporation?
I'm the vice president.
And as vice president at New Mail Corporation, do you do any work in connection with New Medical SC?
I do.
Can you please describe the nature of your work or relationship with New Medical SC?
As part of New Mill Corporation, I am part of the management team that oversees the operation. I specifically deal with the advertising for the clinic and help with the operations.
And at issue in this case, are you familiar with the clinic where Victoria White worked?
Yes.
And where's that clinic located?
It's in Wauwatosa, Wisconsin, specifically at 2600 North Mayfair Road, Suite 350, Wauwatosa, Wisconsin, 53226.
And, what type of services does New Medical perform at that clinic?
At the New Femme Clinic level, we perform services for women for hormone replacement, bioidentical hormone replacement, aesthetic procedures, medically managed weight loss, and some hair replacement.
And did you ever have any occasion to interact with Victoria White in person?
A few times, 3-4 times maybe.
On what occasions would you have to interact with her in person?
If I was out visiting the clinic.
And how frequently did that occur?
As I said, maybe 3 or 4 times over her entire employment.
Now, when Miss White was hired, were you aware if she had any type of scheduling restrictions?
Restrictions, no.
Did you ever have any conversations with Miss White about certain days of the week she wasn't able to work?
Yes, one of the times I was in the office, it was made aware to me that there was some type of family tragedy that she had. And she had, I believe it was her, and I may be mistaken, but her sister and brother-in-law that passed away, and she had adopted their children, and she was attending some type of family counseling sessions on Fridays.
And was that, concern for New Medical to the company?
Well, yeah, I mean, obviously we were empathetic to her situation, obviously having a loss like that and having to take on responsibility of children.
And at some point, and did the company initially provide Ms. White with Fridays off, reduced?
Well, initially she was hired on a part-time basis of Monday through Thursday. Yes, so she never was given the day off. She was only hired Monday through Thursday, from my understanding.
And at some point, was there a reason where you needed to change her schedule?
Yes, there was. We were looking to revamp the office as far as getting advertising. We had finally gotten fully staffed in the office. We had 2 providers. We were looking to have both providers work full-time Monday through Friday.
Now, is there a certain number of patients that a provider can see during a day?
Yes, I mean the office. We are a concierge medical office, and patients, a new patient generally takes anywhere between an hour and a half on the very low end up to 2.5 hours to see. So in an 8-hour day, there's a very limited number of patients you can see.
All right. And so, and are there any particular days of the week that are busier than others at the clinic?
Yeah, historically Mondays and Fridays are our busiest days in the clinic.
And is it fair to say that the more providers you have scheduled for a day, the more appointments you can schedule?
That's the theory. Yes, the more availability we have to see patients, the more we're able to obviously see patients.
Now, at the time you decided to change Ms. White's schedule, do you still have concerns about those initial personal matters that were interfering with her schedule?
At the time we were looking to make the change, I believe we had been informed that the counseling sessions had ended. I don't remember how, but yeah, I believe that was a temporary thing, and we were notified those weren't happening, so we were looking to increase the schedule.
And was there anything in your understanding in Ms. White's employment agreement that prevented you from changing her schedule?
No, our employment agreement actually says that we're able to modify the schedule based on the office's needs.
I'm going to show you exhibit number 3. Respondent's exhibit number 3. This has already been entered into evidence. This response exhibit 3. I'm going to show you the second page, section 1.4, schedule of services. Is this the section of the agreement that allows the company to change Ms. White's schedule at its discretion?
Yes, it does.
And at the time you made the decision to change Ms. White's schedule so that she would work Friday, were you aware that she was pregnant?
No.
At that time, were you aware that Ms. White suffered from rheumatoid arthritis?
No.
At the time you made the decision to change her schedule, did you know if Ms. White had any disability of any kind?
No, we did not.
And how did you communicate this scheduling change to Ms. White?
Via email.
Are you,